next case to come before the court is State versus, actually it's not, yeah, State versus Baker. I'm confused here. Each side will have 15 minutes to present their arguments, and if the appellant wants to reserve any time, you can reserve up to 5 minutes. The court has read the briefs, is prepared with your arguments. I will instruct both counsel that you are not supposed to mention the names of any victims or the names of any children, please. We are recording this. This will be on YouTube and accessible to the public. And other than that, you're ready to proceed.
Good morning, may it please the court. I'm Elizabeth Gaba. I'm here for Jermaine Baker. And this is a case that...
Counsel, did you want to reserve some time?
Oh, I'm sorry.
That's okay.
Yes, I'd like to reserve 4 minutes.
Okay, that's fine. Thank you.
This is a case wherein I filed some motions in the trial court. The trial court denied the motion. It was a motion to reopen the case with a claim that Mr. Baker never had a final appealable order. While I was working on, so there's a previous appeal case, that's 29943. While I was working on the appeal brief, I noticed to my amazement that there were many other things wrong with the case and the sentencing entry, and which emphasized and increased the arguments as to why Mr. Baker never had a real sentencing entry, a final appealable order, and so forth. In that appeal, this appeals court did not consider those issues that had not been first alleged or tried in the trial case, and so subsequent to that, I filed a new motion as regarding all the other issues. And the trial court denied that, and then I filed this appeal. One of the things that I'd like to point out is that in terms of this case, in terms of my arguments regarding that the trial court back in 2007 didn't sentence the defendant on his robbery count, forgot about one of the 2 felonious assault counts, didn't sentence him properly in open court on his 4 kidnapping counts, his aggravated robbery counts, one of his aggravated burglary counts, didn't sentence him in open court on each offense separately, did not verbally pronounce a sentence for each count the defendant was convicted of, and so on. The state does not deny any of these things that I'm saying. As I understand it, the state is saying, so what? And so
Isn't the state saying that all these things are either res judicata or it's a successive PCR?
So, except that in my appeal brief and our argument is, it's not res judicata and it can't be res judicata if, or the state is also arguing, I think, law of the case doctrine, res judicata, and that I can't file this as a 60B. The law of the case doctrine is a rule of practice rather than a binding rule of substantive law, and I listed case law. There's a case called Nolan, there's Mansour versus Crowshare, there's Reed versus Cleveland Police Department, and again, the state isn't arguing that the multiple sentencing entries, including the last one, that they bungled the sentence, that they didn't sentence him properly. They used they being the trial court at the time, used an illegal sentencing doctrine that does not exist in law, and our argument is that neither res judicata nor law of the case nor any of these other claims, that this doesn't apply if the prior decision is not actually a final appealable order. Now, no one, to my knowledge, and without going into the lengthy history of what happened with Mr. Baker, he had other attorneys previous to me who filed various motions regarding certain things. Other than the argument regarding the sentencing package doctrine, nobody made the arguments. I don't know why nobody noticed it, but nobody made these arguments that he wasn't sentenced at all in open court during the sentencing hearing on the robbery court. They forgot about one of the 2 felonious assault counts. They sentenced him in the sentencing entry to certain things to which he was not sentenced in the actual sentencing transcript, and didn't verbally pronounce a sentence for each count the defendant was convicted of. Nobody disputes, by nobody I mean including the state, no one disputes that the numerous sentencing entries created by the trial court never match the words of the sentencing hearing, never address all the charges, and I'm not just talking about charges or specifications for which he wasn't ultimately convicted. I'm talking about charges for which he was convicted. And
So you're saying that he was convicted and it was noted in open court, but it's not on the finalized journal entry that was filed?
And the reverse, where he wasn't sentenced in open court, but we have a journal entry that says he was, that he was.
But on that side, that would just go, wouldn't go to the final bill order issue, would it just go to error on appeal?
Well, it would be error on the part of the court. I don't know how someone constitutionally can be sentenced to something in a sentencing entry for which he wasn't sentenced in court orally. And this happened.
That's why you have an appeal, right?
So he filed an appeal. He didn't appeal with that. And again, one of the things that this court did, and there are multiple sentencing entries, and the reason there are multiple sentencing entries is that defense counsel filed, there were 1, 2, 3, 4, 5 sentencing entries, and that's because defense counsel filed numerous motions for a final appealable order, and the last order, which was the one from December 14th of 2007, doesn't comply with the mandates of the Ohio criminal rules, and there's no legal sentence. The other thing that happened in this case is that the judge sentenced Mr. Baker to 32 years in prison with parole eligibility after 20 years. I made an argument regarding the body armor counts. This is a case where 6 days prior to the jury trial, the state decided to add, it doesn't look like a superseding indictment, it's a document called supplement, to add body armor counts, which added years, 13 new specifications for body armor counts. There was no arraignment. After the jury was convened, so this was 6 days before the jury trial, supposedly the state forgot about it, and then after the jury was convened, then there was an exchange in the courtroom where the assistant prosecutor at the time says, there's one issue we need to address. He was supposed to be arraigned on those specifications, and the court says, body armor spec, how many are there? And it's Ms. Hardy. It says it's on each. Court says, what's the potential penalty? Ms. Hardy says 2 years consecutive. The court asks his defense counsel, you knew about that? And he says, we knew that was coming. The court says, how do you plead? Not guilty. The court says, there you go. It's not an arraignment. That's not a discussion of what these charges are. It happened after the jury was convened. But he was sentenced on these body armor counts.
Was that raised on the initial appeal?
No.
07 or 8 or whenever?
I brought it up in the last appeal that I did, but this was an issue, I believe this was one of the issues that I noticed it when I was preparing his appeal regarding other issues, and this court said, if I recall correctly, this court said, well, we're not going to consider anything that wasn't brought before the trial court.
Was all that available to you on your first appeal to this court, all that information that you just cited to us now from the transcript?
Well,
On the body armor, this was all available to you, you could have raised it on your first motion, you just didn't notice it until appeal, is that fair?
well, I raised it in the appeal.
No, you didn't raise it before the trial court. It
I
wasn't
didn't.
new information you got after you were before the trial court.
I believe that's correct about it's been a little bit, but I believe that's correct about the body armor counts and all these various other issues. There were certain issues that I brought up in the last appeal, but this is, as I was reading this through, I realized that, which is an attorney issue. He has he has a Sixth Amendment right to competent counsel, and none of his attorneys, including me the last time, brought this up. I realized it when I was writing the appeal brief, and the last appeal brief and the previous appeal, and talked about that. But, so there's, again, and I put this in my reply brief, there's an ineffective assistance issue here as to like all of his attorneys, because nobody brought this stuff up. But the issue is, does this man have a final appealable order? And I understand that,
Counsel, you only have about 20 seconds, you're going to say 4 minutes.
that the courts are, believe in finality and believe in efficiency, but here's a man who's been sitting in prison since 2007 who doesn't have a final order, who has an order that doesn't make any sense, that's changed multiple times as to what he was convicted of, where there's a sentencing order where he has 4 years on a count for which he was never sentenced, and so on and so on. So I would ask this court to allow us to reopen that case and address that issue.
Thank you. Counsel, you have 15 minutes, you may proceed.
Thank you, Your Honor. Good morning, and may it please the court. I'm Jacqueline Bergen on behalf of the state to urge this court to affirm the trial court's judgment. Because we've been through all of these arguments once before. We went through each and every one of these arguments the last time this case was before this court. So all of these issues that are being raised today were decided by this court the last time this case came up in Baker 2, and then were settled by the Ohio Supreme Court when it declined jurisdiction over Baker 2 in the wake of this court's judgment. Now, the fact that this court did not remand this case, during Baker 2 to address the other issues that counsel says that she found while she was doing the briefing in Baker 2 does not mean the law of the case doctrine does not apply to this case. And I just would remind the court of a few points. First of all, like counsel mentions Nolan versus Nolan. Okay, that case from 1984, the year I was a sophomore in college. Okay, from the syllabus of that syllabus is dispositive. It reads, absent extraordinary circumstances, such as an intervening decision by the Supreme Court, an inferior court, such as the trial court in this case, has no discretion to disregard the mandate of a superior court, namely this court, in a prior appeal in the same case. That is the syllabus in Nolan. There is no intervening Supreme Court case that would affect this case at all. Agostini, which is the Supreme Court of the United States case that is cited in the reply brief, does not revive the arguments of the defendant in this case. That was a case involving whether public school teachers could go teach in parochial schools in New York City. That underlying case had been effectively overruled in the 12 years that spanned between the two cases as far as the Supreme Court's Establishment Clause jurisprudence. So there had been intervening case law. So in that case, because there had been intervening controlling U.S. Supreme Court case law, that the law of the case doctrine did not dictate that result.
Counsel, we've been down this road before in many other cases. And isn't the rule, obviously, that's established that if the original court order is not final and appealable, then res judicata is not gonna apply, law of the case is not gonna apply, because all of those were void, basically, that the courts never had jurisdiction over this particular defendant.
But this court did decide in Baker 2, at paragraph 13, that the December 14th, 2007 journal entry in this case is a final appealable order. Again, the Ohio Supreme Court did not accept jurisdiction to consider that, and under the pipe fitters and Saline cases, the Ohio Supreme Court has made it clear that when it refuses jurisdiction, a court of appeals cannot revisit the issues in its case. And that's the situation we have here. So this court cannot revisit its opinion from Baker 2 that the December 2007 order was a final appealable order. Similarly, it cannot revisit its opinion from paragraph 12 of Baker 2 that the defendant's sentences in this case are not void. It also cannot revisit its opinion, also from paragraph 12 of Baker 2, that Mr. Baker's sentences are res judicata. It also cannot revisit its decision in paragraphs 9 through 11 of Baker 2 that the motion to vacate that the original one that was filed was an untimely and successive petition for post-conviction relief over which the trial court had no jurisdiction. So those are settled issues that cannot be revisited, cannot be questioned by the trial court, and cannot be revisited by this court. So we have been through each and every one of the arguments that are being raised in this appeal today, down to the formatting errors, the typographical errors, and the punctuation errors in the brief. It's the same verbatim brief except for 2 paragraphs. These issues then have been raised before, they're being re-raised now, and they've been settled.
What are those 2 paragraphs? What's it all different from brief to brief?
It is a brief recitation of the procedural posture that has occurred in this case since the time that this court decided it would not remand the case back to the trial court during Baker 2 and the decision in Baker 2. It does, however, omit the fact that Mr. Baker attempted to take this up to the Ohio Supreme Court and the court declined. So that's essentially the only change. Oh, I take that back. There are a couple of omissions of footnotes, and there are a couple of wording changes and a couple of additions of sentences regarding each assignment of error as to the relief that he's asking for. Otherwise, it literally is the same brief. So again, that's why the law of the case doctrine applies here. The same arguments are being raised, relying on the same case law, the same facts, over and over and over again. And I look forward to the court's questions. Otherwise, the state is going to ask this court to affirm and rest on its brief. Thank you.
You need to see, you had just a little bit less than 4 minutes.
So in the last decision, in 29943, paragraph 7, which the state has not brought up, it reads, to the extent Baker has raised additional arguments other than those he raised in the trial court, this court will not consider the arguments. And then there's a citation to J.P. Morgan Chase Bank versus Burden. And so, although there was a decision last time, the decision was we're not going to consider all of these other arguments that I brought in this case because they hadn't been brought up in the trial court. So so we haven't been down this road before because this court didn't consider all of these arguments. There were other arguments that the court did consider.
What are you saying are different arguments you're raising today, to be clear for the record?
Well, I brought up the arguments that I'm bringing up now, other than the ineffective assistance of counsel argument, are similar. They're not verbatim and they're not exactly the same, but they're similar. There's some different language, but this is not something where I brought in arguments and this court considered them and then said, well, we declined, or we're saying this is res judicata, or we're saying this is something, and therefore go away, Mr. Baker. This court just declined to even address the arguments.
And I'm trying to understand what wasn't addressed. So was the body armor something that wasn't addressed, the argument you brought up earlier?
The body armor, my recollection is body armor wasn't addressed. The fact that, everything that I just brought up in terms of all the various counts, the kidnapping counts, the aggravated robbery counts, the aggravated burglary counts, the felonious assault counts, where he got 4 years on a count for which he was never sentenced. All of that stuff.
He was never sentenced in open court.
He was never sentenced in open
There
court.
eventually was an order that was placed saying 4 years for this offense, but it was never sentenced in open court.
On that count at all.
Right, that's what you're saying. When you say never sentenced, he was sentenced, just not in open court. Is that fair? And we see it here today, are there offenses he's been convicted of that he's not yet received a sentence of in open court or otherwise?
Yes, to the extent that he was given a global sentence and he was not individually sentenced on each count. There are also counts for which there's something that appears in a, and the sentencing entries are different in terms of what he's sentenced to. But as to the last sentencing entry, he's sentenced to a term of years on something or not sentenced at all to something, or we don't know which felonious, for example, which felonious assault count or what it is he's being sentenced to, because it doesn't say. But he's not individually set. There's no individual sentence on every count. There's a global sentence of this period of time to this period of time, and if you look at the different sentencing entries that shifted from one entry to the other, keeping the same amount of time, but as to what the sentencing entry says he's convicted of, they're different.
And his appellate counsel in his first case had all that in front of them and the right to file an appeal on that. Is that correct?
That's correct.
And you had that opportunity on your first motion in this case to file argument regarding that. Did you file argument regarding that in your first motion, all these issues you raised?
No, I filed it in the second motion. I filed some argument, but not a lot of this. That's correct.
In counsel, Judge Stevenson?
I don't know.
Okay. And you're out of time, so thank you for your presentation.
Thank you very much.
As you know, we will take the matter under advisement and will render a written opinion that will be sent to all sides. And also we will